Hi there, this is Janet Gershon-Siegel, and I'm the Lonely Writer. This is serious social media help for the independent author. I am a master's degree candidate at Quinnipiac University, and this is my capstone project. This is social media help for the independent author. Today I'm talking with copyright attorney Michael Stewart. Hi, how you doing?
Hi, Janet. I'm great. How are you?
Great. Before we get started, one thing I absolutely have to say is because both Mike and I are lawyers, and so we have to get a disclaimer out there. And the disclaimer is basically that this interview is for informational, educational purposes only. It is not intended to replace regular old talking to a lawyer and getting advice. And no representation should be either inferred or implied. God, I hope I got that right. Anyway, so feel free to jump in if you need to add anything. Just tell us about yourself.
Well, I am an attorney. I'm located in Atlanta, Georgia. I'm a partner with the firm of Friend, Hudak and Harris, and my particular role is I am leader of the practice group that focuses on technology law and intellectual property. Mm-hmm. So I mainly work with technology companies or technology customers in transactions. Of course, a huge part of technology is intellectual property, so a fair amount of my practice deals with issues related to intellectual property rights online, or as we said back in the 90s, cyberspace.
Al Gore. Well, so as an independent author, I think we run into kind of two different ends of this. One of which is our own intellectual property, anything that we may make, and the other is intellectual property that we may hope or feel or try to make use of or transform in some way. So can you talk a little bit about kind of between literary and pictorial work, kind of how things are protected and sort of where the lines kind of get drawn?
Well, it's a good place to start with what's common between those two, and that is, of course, copyright. Copyright fixes to the work and gives the author certain exclusive rights. And if anyone else exercises those rights without his or her permission, they are infringing. And the exclusive rights are generally to reproduce the work in copies, to distribute those copies, to publicly display or publicly perform the work, which we'll get to, or to prepare or authorize derivative works, taking it and adding to it, modifying it, and making something else. The main difference under copyright between a literary work and a pictorial work is a literary work is, of course, a work primarily composed of text, book, short story, poem, etc. Okay. A pictorial or graphic work, as it's termed in the Copyright Act, is, of course, what you would expect. The rights are a little different. For example, you can publicly display a pictorial work, and that's the right given to the copywriter, as opposed to the right to, say, publicly perform a book or a play or some other written work. But at the baseline, the big thing to remember, because it both affects, as you said, your protection of your own rights and also making sure you not tread on others, is that to the extent the work, whether it's literary or pictorial graphic, is original, the person who created it is the only one who can authorize a use to be made of that work.
Now here's a question I'm sure people are going to ask. Between literary and pictorial, what if I've got a graphic novel? How does that fit into the mix? Which is it?
Well, generally speaking, the copyright law in that type of situation has either made certain exceptions. For example, you could say the same thing about a film. It's pictures and it's moving, but it's got a script. And when it's embodied in a film, the Copyright Act has a special class of works called an audiovisual work, which is specifically a series of moving pictures coupled with sound and text. Okay. A graphic novel, though, I think they would apply the test, a bit of a predominance test. Which portion of the work predominates? And I admit it can be a close call, and you're going to feel one way whether you're the artist or you're the person writing the script for the work. But generally speaking, they're treated as a literary work. Okay. And the accompanying graphics are protected as part of the literary work, just as it would be if the balance was a little more tilted, say, for example, with a truly text literary work that had drawings at the head of each chapter.
Okay.
There you've still got a mix, but because the literary content predominates, the law says it's a literary work, but the protection extends to the graphic works that are embodied in it.
That's interesting. Kurt Vonnegut's Breakfast of Champions actually comes to mind. That's a mostly literary work, but there are occasional drawings in it. And by the way, mentioning a work and reporting on it and discussing it, I know that's protected because commentary is considered fair use. Is that correct?
To some extent.
Okay.
Fair use is very much it's not only a touchy-feely concept in day-to-day life, but even the Copyright Act treats it as a bit of touchy-feeliness. And it's good, I think, to start with what does the term fair use mean, because I think people misunderstand it. Again, you as the author, we start from the baseline that you have the sole right to authorize other people to use your work, meaning you also have the right to stop people. When we hear the term fair use, I don't think people understand the context. It really means the law looks and says, is this other use that is being questioned, is it fair or is it unfair to the author? And a use that would be unfair is something that in some way, for example, strips the financial benefit of the work from the author, or perhaps puts his work in a bad light, assuming other factors are present, devalues the work, because that's ultimately one of the purposes of copyright is to give value to the work.
Okay.
But as far as commentary, the Copyright Act gives 4 factors for determining whether they're copyright, or whether it's fair use. But even the statute explicitly says these are non-exclusive. There could be other factors. We don't know. Good luck. and they also say that no one factor predominates over the other. So yes, long story short, commentary and criticism are one of the fair use factors. And I think that they weigh fairly heavily because they militate toward one of the other purposes of copyright, which is to sort of enrich the public knowledge. But there is no bright line rule that simply making commentary is in and of itself fair use. For example, if you had the other 3 factors, for example, transformative, whether it affects the market for the copyrighted work, if all of those pointed in the other direction, you might have a real question.
So, I mean, we both know that writers, particularly independent writers, were always looking for reviews, and and I think a lot of indie authors are really concerned about negative reviews. And yes, there can be an impact. There can be an economic impact, but I would argue personally that that's absolutely fair use, because very often even a poor review can actually promote a work. I think people don't quite realize that.
Well, and you're exactly correct. Let's remember one of the factors of fair use is commentary or criticism, and quite often criticism is not good, not constructive criticism. It may be just straight out, this work is horrible. I think where you drift over the line, and this is maybe a good example, is, for example, someone has a book and a reviewer wants to review it, and this goes to the fair use factor regarding the sort of how much of the work was taken to make the fair use. And, for example, I take a look at your work, Janet, and I find a sentence just particularly poorly written. And I copy that sentence, and I say, Janet wrote this. This is clumsy and jejune.
It's horrible. I hate it.
That would both not only be criticism for one fair use factor, but I only took a very small amount of the work. Let's take a situation where criticism would likely not be likely, because you never know, be fair use. Let's say I just reproduced your entire book online, and then I added a sentence at the bottom that said, "Boy, this sucks." Yes, I am criticizing. Yes, there's arguably fair use. At the same time, it's hard to defend that I did not take more of the work than was necessary to accomplish my criticism.
Yeah, absolutely. You know, and particularly for, I mean, we're not talking about a drabble of 100 words here. We're talking about a novel of, 50,000, and yeah, you can make your point a lot faster. I think a court would absolutely look at that and say, get to the damn point.
Right, right. And let's last thing on this. Remember, copyright and therefore fair use is all rooted in the First Amendment, right of free
Hmm.
speech, and so you always have that countervailing free speech argument on the side of the reviewer who has a right to, so long as it doesn't cross certain lines, to speak and say, "There's this book out there, and I have to say I did not enjoy it at all."
And that's certainly their opinion, and of course they're entitled to it. Now, let's talk a little bit more about pictorial, uh, because we hear terms like Creative Commons or DMCA, and I think a lot of us don't really understand these terms. And let's start with the real basic, because I know people always have this question. I saw a picture online, I liked it, I right-clicked on it, and I copied it. Is that okay?
Well, most likely not. And I
Okay.
say most likely not because, again, we start from the same point. Uh, that pictorial work was created by an author, and therefore copyright attaches to it. And we're setting aside whether it's so long that it's been out of copyright. It's always best to assume that it is covered by copyright.
Okay.
And just because the internet has increased, one, the ability to distribute works, increase the ease of it, it's also increased the ease of the ability to copy a work. I mean, that's why not why, but it's certainly a good function of the right click button on our mouse. But none of that changes the fact that the copyright still applies. Just because it is there and can be taken does not mean that it legally can be taken. So, when looking at a work online, you should always start from, especially a picture, you should always start from the premise or the understanding that somebody owns the copyright in this, and then do some investigation. As far as investigation, a lot of people may think, well, putting it on the internet, that puts it in the public domain. It does not. Copyright law in the U.S. is very clear. Unlike in the past when you could accidentally put your work into the public domain, now you have to be very clear that you are intending to put it in the public domain. Okay. So if you don't see a statement that's in the public domain, assume it's not. Then the next step before you do that right click is to figure out if there are any published terms stating how that work may be used. The author exercising his copyright to authorize others to make use of it. And oftentimes there are license terms.
Okay.
It may be something very simple that someone wrote on their page. Any page here, please feel free to use in certain ways. Okay. Don't do other things with it. Or they may do a shorthand and simply refer to one of these commonly accepted license forms, of which Creative Commons is one.
Okay.
And, I sorry to interrupt, but there is one other point, and that's the big thing to me about Creative Commons. There is no such thing as a single flavor of Creative Commons. Usually they will say Creative Commons and give a version number. That puts the burden on you to go figure out which Creative Commons sublicense was chosen, and that's vitally important. Creative Commons has at least 6 main types of flavors of license, and then certain subtypes. And simply saying, well, Creative Commons, that must mean everyone may use it creatively because it's common property, which is not at all what it means. Depending on the version, the license may say, do whatever you want, you can change it, you can do anything, but I'd still like the original author's name attached. Okay. Other of the Creative Commons license say, distribute it as much as you want, but you may not change it. And there are numerous flavors in between. So you always have to investigate what rights the author is giving you before simply assuming that you can make the use that you intend.
Okay, and one thing that I will make sure is to put the creativecommons.org link on this video so that people can check this out for themselves, because Yeah, it is complicated, and there are a few versions of it, and you can kind of get tripped up as to who gets which kind of license and who has permission to do what. Yeah, because you can't just sort of slap on a new title and a new author and say, okay, this is my book now. I would also caution people that I, you know, just somebody saying that something is public domain is also not necessarily the case, because there's trolls out there who will claim that something's public domain and it turns out it isn't. And I think the two easiest ways to get something that you absolutely have clear permission to use, one is take the picture yourself and you own it, and another one is buy it. Because then you've got a relationship with whoever sold it to you, and hopefully, presumably, they had the right to sell it. Oh, and certainly, at least you've got something of a defense in court where you can say, well, I acted in good faith under the assumption that this was owned by this particular person. I mean, I can't sell you the Mona Lisa. It's kind of obvious I don't own it. But if it's an unknown piece of artwork and it appears to be mine and I'm selling it to you and we've got a written agreement, then you've at least got a fig leaf in front of you in court.
Right, and on that point, just so there's no confusion, the copyright statute actually states expressly that purchasing a copy of a copyrighted work does not give you any of the copyrights. So for example, even if I go into an art gallery and I purchase the original oil painting of my favorite artist and I take that home, I still don't have any of the rights of the copyright author to make it copies, to make changes to it, etc. I simply have the right to possess and, if I want to, throw away that one copy. So you're exactly correct. Get a written agreement, but the written agreement needs to be specific. You're not merely buying a copy or the only copy of that work. You are also buying the rights you need of the copyright owner.
Yeah, and it's certainly it can be complicated. Now, what happens if I'm on the other end of it and my book is being pirated, or I'm an artist and my my image has been taken, and I want redress? What do I do?
Okay. Well, the first thing to do is, of course, see a lawyer, and the most immediate redress is, of course, an action for copyright infringement.
Okay.
Now, under the Copyright Act, generally speaking, you must obtain a registration in your work and attach the registration to the complaint. So that means making a filing with the Copyright Office, depending on what type of work you're registering. There's a different form for a literary work versus a pictorial, graphic, or sculptural work. Mm-hmm. But you do need that registration. Now, of course, depending on how much money you're willing to put into it, that could be a real roadblock. It's a roadblock because right now the Copyright Office can take up to a year to get your registration back.
Oh, really?
So you're sitting there saying, I need to file this complaint, I need a registration. Some circuits muddy it a bit and say proof of application, but the statute says registration. So what do you do while you're waiting on that? And that is where the DMCA comes in.
Okay.
Of course, the DMCA refers to the overall Digital Millennium Copyright Act, but that was enacted in the late 90s to at least try to address some of the issues that were coming out of this new online environment. And the DMCA has a provision that is really, and it's good to understand, is meant to protect the copyright owner, but frankly, its primary purpose is to protect the online service provider,
okay,
the ISP, the website host, etc. Because under the law as it existed and exists, remember the copyright owner is the only one who can authorize someone to make a copy of their work. When I, a nasty, rotten infringer, take your book and I upload it to a website so that everyone can have a free copy, yes, I am creating an unlawful copy, but so is the service provider, because their machinery is actually creating the copy. It doesn't matter that they didn't know or they didn't intend. So what, under the old law, they would be just as liable as I would. The DMCA lets a service provider a bit off the hook if they respond promptly to your notice to them that your work is being infringed on their service or on their server. What the DMCA says, and this is helpful not only to understanding how to prepare a DMCA notice, but where to send it. The service provider must enter their name in a directory at the Copyright Office, providing information on where you can send its takedown notice, and their online presence, their main website, the Comcast.com website or the Charter.com website or Amazon.com, must also tell you where you can send that notice.
All right.
The Copyright Act specifies what you should put in that notice, and there's a link, I may have sent it to you, Janet, to a good form that tracks what the statute requires. Basically, you will need to provide the service provider with various information. Of course, your contact information and identification of where on their system your work is being infringed.
Okay.
And most importantly, a statement under penalty of perjury that you believe that this activity is not authorized by you, the copyright owner. If the service provider gets that communication and it complies with all the requirements, then they can avoid being liable to you by taking the material down. So this is a good remedy. As I said, you may be waiting weeks, months, or years to get your copyright registration, or you may be waiting for things to go through the court system. This is a good, quick way to sort of stop the bleeding and get work taken down. The potential downside is that if the service provider takes it down, he has limited his liability to you, the author, for having that material on his server. However, as you know, the service provider is at a real risk if someone does a bogus, let's take the copyright trolls like you mentioned, a bit of a bogus takedown notice. They don't have time to investigate anything. If they get a notice, they're going to take the material down. When you provide your initial notice, you have to give them information so they can figure out who uploaded it. Now, they may have potential liability to the uploader because they took their material down. They maybe stopped their revenue stream. So the DMCA goes on to say that, hey, now that the service provider is going to be potentially liable to this other person, they must give them notice and an opportunity to respond. And if the alleged infringer responds and states that, under penalty of perjury, that, hey, this takedown was either the result of a mistake, you know, my work wasn't infringing, or you got the wrong guy, or misidentification. Hey, you said this book was infringing, but, you know, you took down the wrong page. The service provider is then entitled to restore access to the material.
Okay.
So you may be back in a loop of, I got them to take it down, suddenly it's back online. At that point, it can stay online. And unless you notify the service provider that you have filed a lawsuit against the subscriber.
Okay.
So, yeah, I understand that's a bit long-winded, but the point is the DMCA can be a very useful tool to get something taken care of quickly, but it does have some safety hatches where you may find that the material is back online and you have to file the lawsuit to get it permanently taken off.
Well, I imagine that kind of makes sense, though, because it's also, otherwise YouTube is just caught in this endless loop of take it down, then there's a you know, a counter file, and we put it back up, we put it back, you know, and then YouTube doesn't have time for that nonsense, and neither does anybody else. So I think those are all of my questions. Do you have anything else you would you think independent authors should know about copyright?
Well, I think just the basics, obviously. You know, as we've discussed, distributing your work online makes it very easy for someone else to take. As soon as possible, pursue registration of your works. Your copyright is protected from the moment you fix the work in a tangible medium, and for our purposes, it's the moment you hit save on your word processor.
Terrific.
But you're only really entitled to recover the actual damages you suffer and whatever profit the defendant has amassed from your work. And let's face it, if someone's distributing your work for free online, it may be difficult for you to prove your damages, and the other person may not have gotten any profit other than website hits and maybe a little click-through profit. If your work is registered at the time that the infringement begins, then you are, in addition, entitled to potentially attorney's fees for having to chase this person down.
That's big money, folks.
Right. If you may find again that your actual damages and defendant's profits are small, you can instead elect to get statutory damages, which can range up to around $150,000 per work infringed. So the copyright registration procedure is actually very simple and very cheap. I believe the filing fees now are less than $100. It's a simple form with instructions online. And I would really suggest registering the copyright in your work before you publish it, because once you publish it, and by publish I mean putting it online, in the truest sense of publishing, there are some exceptions where if you slipped a little and you registered it within 90 days after publication, you might get benefits. But let's go for the safe, prudent approach, which is if you're getting ready to publish your work, go ahead and file the application for the registration. The registration may not come for 6 months to a year unless you pay about $700 in expediting fees, but you're basically protected as of the date you made that filing.
Fantastic.
So, don't let your, so to speak, don't let your work out there without a rubber raincoat and some galoshes.
It sounds like a really good idea. And just to clear up one thing, because every now and then I do see this, mailing it to yourself, that doesn't mean anything at all, right?
Absolutely not. It's often referred to as the poor man's copyright. The best of what it establishes is if someone says, hey, I wrote that book back in 1979, and you say, prove it. If you can hold up an envelope that has a 79 postmark sealed with the work in, that might help you there, but it does not substitute for a copyright registration. And certainly you would not be able to claim any of the benefits like statutory damages, attorney's fees because of that.
Okay, so definitely instead go for the registration. So I'd like to thank Michael Stewart, Esquire, and thank you for listening, and we'll see you again next time. Thanks.
Thank you, Janet.